process of.
Thank you very much. I reciprocate. Similarly,
We can assure you, Lordships, that we will have a great innings together.
after 8, I will be seeking all your cooperation. So, okay, thank you.
For judgment, item 1.
It to 28th.
So we, one thing we do, admit this appeal and fixed on that day,
28th.
28th.
No, sir, kindly send order dated. Main order kindly.
This is from the same judgment, the other appeals has been faced on 28th of August. All
Why
right.
are you disputing?
Sir, 2 year ପରେ ଆସିଛନ୍ତି.
We understand, that is why you have,
ଏଇଟା appeal ଟା 1 year ଭିତରେ sir ହବା.
1 year ଭିତରେ.
1 year. 1 year.
list this matter on 28/8/2023 along with 44.
44, my
Case number is 44 along with WA number such and such for hearing on merit. Mr. M.K. Kuntial and additional government advocate. There is a prayer for condemnation also, there is no notice.
Sorry.
Condemnation prayer has not been allowed.
Has the delay been condoned?
No, my lord, that only notice has been issued. He has
He has
appeared.
appeared.
So as similar matters were fixed, he admitted on that day that all the matters will be heard. Now he is raising an objection on
No,
limitation.
no, are you challenging the on the ground of limitation?
Yes, ma'am.
Are you challenging the condemnation
copy.
prayer?
Copy not sir.
So copy not served.
I am serving
Just
just
code
now.
out. Mr. Kuntial serve the copy.
I'll serve just now, my lord.
Okay. It has been stated by
Thank you.
Mr. K.C. Sahul and counsel appearing for the opposite party, given the IA number 363 of 2023, that he has not received the copy of the application seeking condemnation as said. We direct Mr. Kuntial, M.K. Kuntial and additional government advocate to serve a copy of the application in the course of the day. Let the matter be listed on 3rd of August 2023. Meanwhile, the opposite party may file their objection if any. All right, it will come on 3rd of August.
Well,
Same in the next item also, there is a
Same.
delay.
Same.
Some lead case sir.
Me-
You are also appearing in the next case, item 4.
Connected case is posted to when? Connected case posted to when?
28th August.
20 na 28?
28.
Same order. Here is a delay. You have not also received the copy?
Yes, in this case he has received and I'll serve another copy.
All right, the same order we are passing then. All right. This is on condemnation application, pass this order. 5.
Item 5.
My lord, the petitioners are the jail warders, my lord, who are awaiting for their promotions, my lord. And the opposite party number 5 prepared a gradation list on an annexure 1, page 33, my lord, where the petitioners' names were there. But since no action was taken, thereafter the petitioners filed representations before the opposite number 5 on annexure 4, as page 51, my lord. Thereafter, the representations, when no action taken, basing upon the representation,
You are challenging what?
the promotion, my lord. My representation was rejected, my lord.
You are challenging a notification only in this order, why this is coming to the division bench?
This is a single bench matter, my lord. Earlier it was also single bench.
Yes, challenge the virus of rule. Odisha subordinate jail service method of recruitment and
There is
condition.
no reference in the prayer. Their prayer only such notification is there.
That prayer.
Oh, relaxation clause.
And what is the ground? Yes. I don't understand how.
Is not very clear. Are you challenging any rule?
No,
The
yes.
second prayer.
Since the new notification regarding the promotion was
No,
arrived.
the
my lord.
annexure 5 is a notification only. This is not rules. It contains rules.
That is the rule, Your Lordship. You can find page 73.
All right. Oh, it's rule. This is the reason.
So that he has given that
Right.
only on the
Have you
ground that
removed the defects?
My lord.
Have you removed the defects
Earlier defect was second copy was not
that you have supplied?
my lord.
All right. We issue notice.
my lord,
So because you challenge against rule.
the only ground that he has not got promotion in the meantime, so he has challenged the vice.
Right.
Rules on what ground? Just saying rules.
New rule has since new rule has came, my lord. That is the only ground the representation was rejected, my lord.
It's all right. You have challenged that rule. We
My
have to
lord.
hear you.
My lord.
Heard Mr. S.S. Das, Lord Counsel, appealing to the petitioner. Issue rule returnable on 24th of August, 2023, since Mr. M.K. Kuntial and it.
Annexure 8, my lord. They will proceed with the test, promotional test. That will remain state, my lord.
appears for the APS and Web's notice for the respondents, no formal notice is called for, but Mr. Das shall ensure supply of 2 additional copies of the read petition to Mr. Kuntia by tomorrow. All right.
Then his release claim form are contrary to each other. In one he says relaxation be given and another
Yes.
he's challenging the rules containing the relaxation clause.
So it will come on 24th August.
Annexure 8 shall be said statement.
State rules,
And Annexure 8, they will proceed with the.
they will proceed because unless the rule is interfered with, you don't have any right. And the basic principle of the prima facie court has to believe the constitutionality of the rule. We cannot pass such order. You come prepared on the next date.
And that will subject to the result of the writ petition. my lord. Annexure
All
8.
right. Any promotion made under the impugned rules shall be subject to the final outcome of this writ petition. Okay, fair enough.
Item 6.
May I please your lordship? And annexure 2 is pending before the OP number 2 regarding settlement of illegal settlement of Sairat, fishing Sairat against the in favor of the OP number 3, my lord. For that I have given the representation to the video, my lord. OP number 2 is pending.
Yeah.
How you are aggrieved?
My lord, it is due process, it is auction, my lord. Sairat, fishing Sairat will be auctioned every year, but they have not doing so, and they so much settled in favor of the OP number 2, OP number 3, my lord. For that, I have given the representation to OP number.
Are you interested in getting the settlement?
illegal-
Are you interested in getting the settlement of the canal?
My lord, auction. I want.
You are also interested.
Auction. I want auction, my lord.
If auction is held,
Public-
you will participate.
Participate. I will participate.
Well, we are recording the statement and dismiss your public interest litigation.
My lord, we are the villagers of.
But you are interested,
Garimur.
all villagers will not participate in the auction.
Some
You have a
parts-
definite interest in the auction.
It is the benefit of the.
No,
What?
no.
It is the
Village.
benefit of yours. Villagers will consider later on.
If your writ petition
What is the basic
entertained-
principle of the public interest litigation? You should not have any interest in the subject matter. You are only consider the public interest. You are yourself is submitting. If the auction is called out, I will also participate.
My lord.
So you have a definite interest in the matter. How
Mm,
can you maintain
we
a
are-
public
we are the-
interest litigation?
We are the villagers of.
You are
this
not
is-
understanding. If you are interested in participating in the auction, it can't be a PIL.
Without.
You have an individual thing, you can approach saying, I want to participate to hold auction. It can't be a PIL.
Without any.
It can't be a PIL.
No, annexure 2 may.
If you undertake that you will not participate in the auction, then it is a different matter.
Hello, annexure 2 is pending.
Can't be.
Is made
In a
to dispose
PIL,
of
it can't be.
All right. That is much better that we dispose of. Mr. Mohanty, are you appearing in this matter? This annexure 2 is the representation filed to the block development officer, Rajnagar. We'll say
Video.
that this is the allegation, you inquire and take the appropriate action as prescribed by law. All right? All right, but you don't come in future because he just impose huge cost on you. If I find an interested person under the garb of the public interest litigations trying to promote his interest in the court. This is a special jurisdiction has been created for purpose of looking into the marginalized people and general interest relating to the public trust like environment and other issues is.
Actually, he could not.
Please
present
don't
it
venture in
properly.
this litigation in future.
Actually, he could not present it
Yes.
properly. He is appearing for the villagers, not for any intending bidders, as I find.
No,
out.
he is a major.
No,
But
auction
yes, yes.
He
He
it
made
is
a
like to be
categorical
placed there
statement. If
by
the auction is called, he said, I will participate.
Yes, yes, that is.
So how can he maintain a public
No,
interest
in that
litigation
case,
then?
PIL is not maintained.
You are Mr.
If
P.K. Rautre.
S. Behra.
Mr.
S. Behra.
Mr. S. Behra and counsel appearing for the petitioner has submitted that in breach of the rules, the Jalli Canal has been settled without following any other transparent method. So in this regard, the petitioners have filed representations to the block development officer to take the corrective measure and to follow the procedure as prescribed, i.e. to settle the Jalli Canal by auction stuff. Without making any observation or comment on the procedure, we direct the block development officer to whom you have filed the representation.
Open number 2, my lord.
The respondent number 2 to take a decision of the representation annexure 2 to the writ petition within a period of 2 months from today. If the petitioners are interested, they may file an application before the block development officer for hearing. In terms of the above, this petition stands disposed of. A copy of this order is supplied to Mr. D.K. Mohantilan, additional government advocate, who is appearing for the opposite parties, opposite party number 1 and 2. Stop. Since we have not passed any adverse order against the opposite party number 3, we have not issued any notice. All right.
Item 7.
May I please? Here, the validity of rule 4 of Orissa Group B, C, D, appeal and special position is on the 10 books. Similar matter has already been fixed to 20.
This is a similar group of petition is
Yes, the lordship has fixed it to 24th.
24th.
Supply
Or-
the copy early.
and see out and counsel appearing to the petitioner. By means of this petition, Rule 4 of the Odisha Group B, Group C and Group D post to the repeal of special provisions rules 2022 has been challenged. Issue notice returnable on 24/7/2023. Since Mr. Kanthial and it regional government advocate appears in notice for the opposite parties, no formal notice is called for. The opposite parties are directed to file their counter affidavit, if any, by the next date. They are given liberty to adapt the counter affidavit file in any other analogous writ petition. Do you need extra copy?
No,
All right. The similar interrogatory is subject to the final outcome. We are
Yes,
passing
yes.
the same order. You just follow this. The second order IA, huh? Same order will be passed in the IA. Just have the number. Is next.
Obliged. Item 8.
May I please your lordship. My lord,
Yes.
petitioner filed this application before your lordship seeking Lords with a prayer for Honorable Court's intervention because of lawyer strike in their locality for unlimited period. Local people are suffering and also unable to represent it.
All right, just would you kindly come to your prayer in the writ petition
My lords,
and read it a bit loudly.
my lords.
Read it. What is the prayer before this court? We have to find out from the prayer that you are making this prayer before this court. You read it.
It is therefore prayed that this honorable court may graciously please to issue notice to the opposite parties and after hearing the parties direct the authority concerned to look into the matter and take appropriate steps for better interest of the general public. Issues that
No, just I did not understand. What step, what regard, nothing is reflected in the relief part. You take the for the betterment of the public in general. What in what regard, on what area?
I have narrated in my
Sorry, you just take time and properly frame the prayer. All right,
my lord.
let the matter be listed on 3rd of August 2023. Petition is permitted to amend the appropriate part of the writ petition to make it understandable the what relief the petitioner has paid before this court. Okay. Mr. K. Pradhan Land Council is appeared for the petitioner and Mr. J.P. Patnaik, Land Government Advocate is appeared for the opposite parties. Be careful. When you file a public interest litigation, it is not the epistolary jurisdiction. You write a postcard and the court will take it. You are formally filing an application before the court.
Sorry, my lord, I am avoid lordship's direction. I am ready to avoid lordship's direction.
Appearing for the opposite parties number 1 to 5. All right. Because the opposite party number 6 is a bar association.
My lord.
Item 9.
May I please, madam? The constitutionality of Rule 4 of Odisha Group B, C, and D post repeal and special provision Rule 2022 is under challenge before your
All right,
lordship.
heard Ms. Madhumita Panda copy the earlier order. This NC House case, it will come on 24th of July.
My lord, there is a miscase.
We'll pass on subject to the outcome of the writ petition. The similar base 24th July, Mr. Kuntia.
24th.
You, Mr. Kuntia's name, not same way, just
Item 10.
next.
Item 10 is similar to 7. The rule 4 of the
Same
BCD.
order, just name of Mr. Saul, M.K. Saul for the petitioner.
The same order we issue.
Same order,
Well,
same.
Subject of
24th of July.
12.
When the petitioner is filed an I number 31 of 2023 for withdrawal of this case, my lord.
I number 31,
For the petitioner, my lord.
31, okay.
Item 12, may I please, your lordship?
So they have filed an application for.
Yes, sir.
Well,
Yes.
You are Mr. G. Sahu.
G Sahu, my lord.
In the I number 59. 31. So this is an application, heard Mr. G. Sahu, for withdrawal the writ petition being WPC CRL 109 of 2021. The prayer stands allowed. Stop in the main WPC CRL in view of the leave granted by the order passed today in I number 31 of 2023. This writ petition stands dismissed as withdrawn. MS.S. Patnaik Lanet, additional government advocate is appeared for the opposite parties, state opposite parties. You are appearing for whom? 4.
I am appearing for opposite party 4.
Mr. Ashok Mohanty and Senior Counsel, listed by
Opposite party
Mr.
number
P.
4.
K. Das, Land
Yes,
Counsel, has appeared for the opposite party number 4. So it is withdrawn.
Item 13.
Please.
My lord, it is a case regarding the correction of a spelling in surname in the board certificate, my lord. So, my lord, with due apology, as per your lordship's order, I filed the undertaking before the National Testing Agency, and they have allowed me and assured that within 2 months you will produce the revised certificate. So, my proposal is being initiated by the grassroots level headmaster. So, and headmaster will send proposal to the district education officer. District education officer will send proposal to the board. So I will surrender the old certificate and thereafter they will revise certificate.
So you don't press this application?
No, my lord, I pray because this process is going on. So it might be delayed at the headmaster and the DO level because board has no objection. So I pray the special messenger I will take to the DO and headmaster. So they will apprise your lordship steps taken by them regarding submission of proposal, and I will cooperate with them. Because the public Supreme Court says the public documents like birth certificate, Aadhaar card, voter card, PAN card, it will be accepted as a piece of evidence. And its recent judgment 2020 Jigya Jadhav case. So the regarding change of any certificate, the name, surname or spelling certificate, the my lord, comprehensive guidelines are being prescribed by Supreme Court. So it is permissible to me because entire documents are with me, public documents, and it is acceptable. So I will submit the required documents, Aadhaar card, my parentage certificate, my PAN card, and other related documents. So accepting these documents, the headmaster will submit the proposal to the DO, then DO to the board. So I pray the headmaster.
Yes, ma'am.
Let
him submit all the documents. I'll instruct the DO and headmaster. They will act.
All right. Mr. What is the decision of the Supreme Court?
Yes.
Give it to me. Mr. Shubhranshu Bhushan Mohanty, Learned Counsel, appearing with the appellant, has submitted that for purpose of establishing the identity by name, the documents, namely Aadhaar card, PAN card of the parent, and what is the other document?
My lord, birth certificate. I am possessing now birth certificate, Aadhaar card, election card, my parentage, and
etc. may also be considered for correction of any public record. In this regard, Mr. Mohanty and Council has placed a reliance on the apex court judgment in Jigga Yadav versus Central Board of Secondary Education and others, colon 2021, 7 SCC 535. All right. We direct the headmaster, which school?
my lord, headmaster. OP number 4, my lord. Headmaster Nahakani High School.
Headmaster Nahakani High School, Ramkumarpur,
my lord.
District Kotak, to accept the documents for the petitioner for purpose of correction of his name in the admit card.
Also admit card.
In the admit card only.
My lord.
Name wrongly spelled where?
My lord.
Name wrongly spelled where?
In the certificate and also admit card.
In the this is certificate and the
It's a
admit card issued by the state board.
Board of Secondary Education.
Orissa Board of Secondary Education in favor of the petitioner. Stop. We direct the state headmaster to accept the document and send those to the appropriate authority with his
My lord,
comment.
my lord, district education officer.
Okay, he's send those documents with his observations to the district education officer. Within bracket, the opposite party number 3.
Three, my
Or respondent number 3, within bracket, who shall forward those papers to the secretary, Board of Secondary Education, Kotak, for appropriate amendment in the certificates, namely, give the name of the certificates. What is the name of the certificate?
My
Give
lord,
us.
high school certificate examination.
Namely, high school certificate.
High school certificate examination.
Examination cannot be a certificate.
High school cert.
No, what is the certificate?
My lord,
The
certificate.
board certificate?
Board certificate. Board certificate.
Namely, the board certificate, the high school. What is a plus two
No,
examination?
my lord, class 10.
Uh,
Class 10.
These secondary education.
My lord, it is reflected Board of Secondary Education, High School Certificate Examination.
Or the certificate relating to the High Court certificate examination.
High school.
Yes, which year?
Of the year, my lord, of the year 2020.
2022. And the other document where the petitioner's name has been spelled as, what is the spelled as how wrongly? What is the wrong spelling?
My lord, proper spelling of the surname.
Not proposed. What is there? First tell me that.
P-A-T-T-A-N-A-I-K. Shivam Patnaik.
His second name has been spelled as
P-A-T-T-A-N-A-I-K.
P-A-T-T-A-N-A-I-K, huh? Just surname. Stop. But his family surname and his surname in other documents is spelled as P-A-T-N-A-I-K.
P-A-T-T-N-A-I-K.
It is wrong according to
Yes.
you. Now it will be P-A-T-N-A-I-K.
No, P-A-T-T-N-A-I-K.
So-
A would be omitted.
Double A is there.
No,
What has happened? I am explaining.
Yes.
Earlier was P-A-T-T-N-A-I-K. So he wants it P-A-T-T-A-N-A-I-K.
No. A would be omitted. Originals, my lord.
You just give which will be scored out and which will be this. Give a slip to me. I'm not getting from your records. Stop.
Is paragraph page
We'll also direct the secretary.
Script.
Board of Secondary Education. Board of, what is the secretary is called? Board of Secondary Education to make the due correction as expeditiously as possible, but not later than the 15 days from the date when we will receive all the documents from the district education officer. Stop. In terms of this writ petition stands disposed of, a copy of which will be supplied to Mr. M.K. Kuntiya, Learned Counsel, so that the district education officer, so that the headmaster, Nahakani High School,
Ramkumarpur.
all right. The respondent number 4 sent his recommendation with all documents that will be filed by the petitioner within a period of 7 days from the date of getting the documents. Similarly, the district education officer will disperse those records to the secretary to the Board of Secondary Education, Cuttack, within another 7 days with his observations.
Well,
stop. A copy of this, in terms of the above, this petition stands disposed of. A copy of the order be supplied to counsel of the parties by tomorrow.
Item 14.
Item 14, your lordship. The counsel of the appellant is of our chamber, your lordship, and he is currently ill.
Who is ill?
The counsel of the appellant, Mr. Pratyasis Mahanti.
It has been stated that Mr. P. Mahanti, Learned Counsel, who usually appears for the appellant, is unwell and is not attending the court. In view of that, let the matter be listed on 3rd of August, 3rd of August 2023.
As far as the defect is concerned, your lordship,
In the meanwhile, the defects is identified.
That has already.
that has already been
Complaint.
No,
complained.
it has been stated that the defects have been removed. But still there is a reflection that the defect number 5D has not been
That
removed.
is
That is
compliant.
regarding. That is
So
regarding
it
the
has been
service of
stated
property.
that the defect number 5D also has been removed in the meanwhile. You are appearing for whom?
My lord, I am for the next two matters which arises out of the very same common judgment. So all these cases may be called on 3rd August.
All right. So only the date should be given.
My lord?
In other two matters, you are appearing.
Yes, my lord. Same same objections were pointed out by the registry. And that has also been complied with by the same.
All right. So there are another two matters, this
Another
15
two
and
matters
16.
arising out of the common judgment.
So the same date we fixed.
Same date,
those.
same.
So Mr. B. Mohanty and counsel appearing for the appellant has stated before us. The defects as reflected in the SR has been removed. It is removed already.
Right, yes.
So since the judgment which was challenged in WA number 85 of 2020 is also challenged in this appeal. Let the appeal be listed on 3/8/2023. So of the same order also in 16, right? Same order. Council name will be same. 3rd of August.
Can it be on 8th of August? With your lordship's permission.
All right, make it 8th of August
Obliged.
much better. 3rd of August, lot of matters are fixed.
Obliged.
Okay.
Obliged.
All three earlier item also that you change the date. Where were the 3/8 appearing now? Also, make it 8/8. Yes.
Item 17.
I'm appearing for the opposite party, my lord. I'm not getting pension for last 8 years.
Okay.
A criminal proceeding was initiated.
What happened? Where have you? Are you filing this appeal?
Yes, I am for that. Your Lordship, may see the last order. My Lord's order 19/5/2023. There your Lordship has directed appellants will first satisfy this court the return of benefits and admitted amount of interest have actually been released to the for this court on the enter present treat of it. Well, we have taken steps for release of his all return dues that will be released within 15 days so that matter can be taken up thereafter. I have got the instruction.
Assurance within 15 days they will release all the amounts due to you. You also check up whether they are releasing the entitled amount or not, and we are fixing the matter after 15 days.
Obliged.
You come on the 8th of August, Mr.
I will lordship do. All right.
All right. Mr. M.K. Kuntial and counsel appearing for the appellant has assured this court all due entitlements relating to the pension and other retail benefits will be released within 15 days to the respondent. So in view of this said statement, let the matter be listed on 8th of August, Mr. Kuntial.
9th, your Lordship, why 8th is other matters are coming. So
All right, 9th of August, 9th August 2023. Mr. KP Mr. and senior counsel appearing for the respondent. Who is appearing for assisting you now? Anyone is there to assist you? This mic is off.
But the single respondent is there. Only one respondent.
I am asking for your single associate who is assisting you.
My lord.
I am asking for your single associate who is assisting you in this case.
A Mishra.
Mr. A. Mishra. He is visible and invisible.
Another court, my lord, he has just lost.
That's the problem. Okay. Don't write only Mr.'s name. Okay.
Therefore, my lord, the Supreme Court said, unless you have an advocate on record, you cannot argue. You will not be allowed to argue.
And we say the senior counsel will not be allowed to argue without an advocate who is assisting you because you have no locus otherwise to represent a client. That is our difficulty by law.
I'm sorry, man. All right.
Item 18.
Lord, my learned friend Ms. Rath will lead me in this matter. I will be assisting her, though my matter is in the first. It's a wonderful statement.
I'm obliged for that. Lordships, I would be placing the second matter in that serial, 1380.
Hmm. Just give me some idea regarding what is the controversy is about and why you are challenging the judgment of the land civil judge.
In fact, your lordship will find that there is a IA for leave to appeal. So we were really not parties there. I think in that IA is taken, my first ground is made out.
Okay.
That's IA 4117 of 2023.
IA is in the first appeal.
Writ appeal number 1380.
Or not in the first appeal.
That's the second one in the serial.
First one also we have sought for leave on the same.
It's all right. Let us see. So you'll be arguing on this 1380.
Lordships.
4117, 2023.
Lordships. The issue here is regarding the two gradations, two cadres. One is the sub-inspector gradation list, and then further promotion to the inspector. Your lordships will see that the benefit which the petitioners got in the...
No, this is a writ appeal. Why you need to file a leave to appeal?
We were not parties. We were not parties in the...
All right. But you are affected by the judgment.
Yes, your lordships.
All right.
Your lordships, there is a gradation list which we have annexed in that very miss case, in that very IA.
Yes.
That is a tentative gradation list of sub-inspector of police.
Yes.
Your lordships, the first appellant's name finds place at page 8 of that IA at serial number 419.
419 is first.
Arun Kumar Naik.
Is.
Similarly,
all right, just we believe that
yes.
How they have been affected by the judgment shows.
What happened is they have now, by virtue of the judgment, are going to be deemed to be senior to us.
Okay.
Though they have later entered into the cadre, the court has given them a benefit that no, your entry into the cadre will be taken from a back date, giving its own reasoning. So that is why we should have been heard. We were not made party, especially when the gradation list was there. That's one aspect. After having done that, for the purpose of...
Whether in this application any notice was issued earlier?
No, your lordship.
I think they should have also been given notice because the private parties, they might have said whether the yes, issuing notice.
Obviously.
All right. Oh, just simply issuing notice on the leave application.
Yes.
At MSP Roth Leonard Senior Council. Who is assisting you?
Adyashakar.
Assisted by such and such. Stop. This is an application seeking leave to appeal. As the appellants. Appellant was not a party in the writ petition. Being WPC number 2548 of 2021. But by the order dated 3/5/2023, as passed by the learned single judge disposing the said writ petition, the petitioner's position in the gradation list has been affected. Stop. Issue notice returnable on 22nd of August 2023. Since Mr. M.K. Kuntial and counsel appears in waives notice for the opposite respondents number 1, opposite parties number 1, 2, and 3. No formal notice is called for in respect of those respondents. However, the applicant shall take steps for service of notice on the remaining respondents by registered post 880 by tomorrow. Stop.
Lordships, is one issue. Apart from me not being heard, there is a direction by the court that a review DPC will sit, and the respondents who are only 4 years through this require
It has
10
been
years.
stated by Ms. Ratho and senior counsel. There is a direction in the order impugned that the review DPC should shall and reconsider the matters.
Yes, we
fresh.
In a time fixed.
panel. So
Time.
that's
All right, the review division may sit, but they shall not, their recommendation shall not be given effect to until further order.
Lordships.
All right.
My lord, in the first matter, the
Similar things.
yes, only the counsel, assisting counsel with me is Subhankar Rao.
All just right. Other matters will be similar, but give the prayer portion, find out the name of the case number and the annexure 1. Usually this is the date of the judgment. Date of the judgment is same, right? It is a common judgment.
Yes, common.
Common judgment.
Common judgment.
Okay. Only see the writ petition number in the prayer, huh? It is there. Okay.
The council's name is recorded. Deeply.
Item 19,
19 permitted to withdraw with liberty to file a better. Permitted to withdraw with liberty to file a better.
So we filed memo.
Yes.
File it. Council, what is your good name?
Bhagavan Biswal, B. Biswal.
B. Biswal. Mr. B. Biswal and counsel appealing for the petitioner is submitted a memorandum seeking leave of this court to withdraw the writ petition with liberty reserved in favor of the petitioner to file a fresh petition if the circumstances so required. We do not find any impediment in allowing this leave, and accordingly it is granted. So consequentially, this petition stands dismissed as written with liberty reserved in favor of the petitioner to file a fresh writ petition on the same subject matter. If the circumstances so require, the memorandum the memorandum seeking leave is taken on leave on records. All right, Mr. D.K. Mohanty, learned additional government advocate, has appeared for the opposite parties.
item 20,
None appears. When the matter is taken up, however, Mr. D.K. Mohanty, an additional government advocate, appears for the opposite parties. All you can appear for all? I don't think so. Appears for the opposite parties number 1. So there's no notice was issued
No, it is, for the first time it is.
on advance notice. So let the matter be listed on 8th of August 2023. If on that day there is no representation from the petitioner, will be proceeded to pass an order for non-prosecution. Is
21,
none appears. However, Mr. D.K. Mohanty, an additional government advocate, appears for opposite parties on advance notice. Same, if on the 8th August. Same, if not representative.
22,
It may please your lordship, my lord. As per your lordship's direction, filed an affidavit without making a new pleading. That I attach the document regarding that multipurpose flood shelter. The lordship asked me to answer as to whether it is to be constructed in the school premises or not, my lord. I filed that affidavit to your lordship, kindly see 3/7/2023 affidavit. The multi-purpose shelters means, my lord, first your lordship can come to page 7 of that affidavit. Both cyclones, multipurpose multiple cyclone shelter and multiple flood
Mr.
shelter.
Mohanty, that do you need to take any instruction on this affidavit?
That we have filed affidavit also.
Same document they have filed.
Okay, so there is no question. What is this, your stand in the counter affidavit?
My lord, previously this particular issue was adjudicated by the collector. That order was challenged by one of the sarpanch or ward member. That was the writ petition was dismissed for default. Thereafter, another ward member has filed this. That collector's order was confirmed by the Honorable High Court. Then another ward member has filed. Now, just a bit. Now, we have filed the status report pursuant to the order of the Honorable Court, and we have filed the.
What is that status report?
Yes, it is there. 12th May 2023.
I submit my lord.
Just a minute, let me see the record, government records first, then you.
12th May.
12th May. Separate status report is a part of your affidavit.
It is a part of the affidavit and status of the project.
That's filed by the opposite party number 4.
Filed by the BDO, Bhandari Pokhari.
With the photographs that you have filed?
Yes, we have enclosed the photographs.
Okay. So the construction is stopped by this court?
Yes, that is there.
It is stopped. We'll hear the matter finally on 8th of August. As agreed by the council for the parties, let the matter be listed on 8th of August 2022. When the matter will be taken up for final disposal, Mr. M.K. Mohanty, learned counsel has appeared for the petitioner in this public interest litigation, and Mr. D.K. Mohanty, learned additional government advocate, has appeared for the opposite parties. Yes.
23.
But item 23, this is against an interlocutory order. I am appearing for the respondent. Interlocutory order. REIT applications, entire records has come in the REIT application, therefore the REIT petition could not be disposed of in the meantime, though the REIT application is of the year 2016. So that is why we made an mention on my behalf.
This submission, how? This is whatever has come before us is a scanned copy of the writ petition.
An interim order where this Honorable Court had directed the crime.
Mr. Rautre, that these records that has been placed before us, not the physical records. It is only a scanned copy of the writ petition, and that cannot be.
That is the problem, because the office is not also not listing the matter on the ground.
You
because
mention it.
Yes.
There.
You also clarify that so that at least because that is the problem, and the entire institution, they are not getting their salary for last 3 years.
Who is appearing for this appellant?
That the present case has been posted on 29th August 2023. Now that my lord, my senior has filed a interim application for preponing of the matter. That,
all right, that will be decided by the learned single, just not by us.
Yes.
In this case, I am for the respondent 6. And I think it appears from the noting that the respondent 5 has filed a counter. The copy of the same has not been served on me. I pray for service of that.
Then a counter before the learned single judge, not before us. You filed the counter?
Yes. Yes, no.
The counter in
So far the respondent number 6 is concerned, he has not filed an appeal. Appeal has been filed by the petition and the writ application. Now matter is pending before the single judge. So far as the counter in the writ application.
What is the interim order that you have challenged by this appeal? Let us examine
the matter, because in the event the appeal is allowed, in the event the appeal gets defeated, then definitely I will be affected because I am the senior person.
Come to page 39 of your memorandum of appeal. Page 39.
I don't.
I think this is the order you have challenged.
Yes. Writ petitioner has challenged. He has not challenged. Yes, sir.
let this matter be called.
Who is appearing for this appellant? You are appearing for the appellant?
Yes. I pray, my lord, the matter may be called on the first week of August. Mr. Samuel will advocate.
Read petition is pending, so it can.
It can be, yes. The single judge can hear this matter or
all this matter.
I have nothing to say. Finally,
on merit, it can be decided
Yes, sir.
before honorable single judge.
and there is no stay of the further proceeding of the
No,
writ
no, I
appeal.
don't understand what is the direction of the court, how the this The appellant can be affected. Director General of Police is directed to look into the matter and refer the matter before the crime branch to be investigated by the officer not less than the rank of Deputy Superintendent to submit the report preferably within 8 weeks from the date of receipt of the copy of the order.
Yes.
How you are affected? Tell us how you are affected by the order.
That
Court can stop any investigation.
no.
Investigation doesn't violate any human rights or the legal right. Investigation is mere inquiry for collection of the materials whether the crime has been committed by you or someone else. You just show me this order. I don't know why. Hence, in order to ascertain the aspect of the matter, the court thinks it is proper to refer the matter before the crime bench of the state to investigate. How you are coming in the way? This is the all directions, the two part of the direction. One is observation part that we think that should be referred to the crime branch, and the other, the specific direction has been given to the Director General of Police to look into the matter and refer the matter before the crime branch to be investigated by the officer. The first part of the direction, first it will be examined and verified by the Director General of Police whether there is any material, and if he thinks so, he will refer the matter to the crime bench. How you are affected by such order?
I feel that matter will be called on Monday, Mr.
Not Monday. What for this? No Monday is required. How you can be prejudiced by such kind of a very general type of order for an investigation? We are dismissing the appeal. You go to the single judge, and if you are you correct? This is the order you have challenged.
No, only I pray Monday at least on behalf of Mr. Sam.
All right. At the request of you are Mr. Sahu?
Mr. Mahapatra, PK Mahapatra.
At the request of Mr. PK Mahapatra and counsel, appearing with the appellant, let the matter be listed on Monday's 24th. The matter be listed on 24th. To satisfy us, how by the impugned order dated 17/5. It is the 17/5/2018 order?
No interview.
You have challenged?
No interview.
How by the order dated 17/5/2018, the appellant has been affected, giving him the status to prefer an appeal, intercourt appeal against the judge, the said judgment. Mr. You are appearing for whom?
I am appearing with the opposite part to respond number 5.
Mr. B. Rautri and senior counsel estate by Mr. Biswal.
SK Swine. SK Swine for the respondent 6. Santosh Kumar Swine.
Just whom
I am appearing for respondent number 5. He is appearing for respondent 6.
No. Who is assisting you?
Mr. Sakti Sekar. Mr. Sakti Sekar.
Mr. Sakti Sekar appears for the respondent number 5. And Mr.
Sakti Sekar.
Your good name, sir?
Santosh Kumar Swine.
Mr. S.K. Swine and counsel appearing to the respondent number 6. Where is Mr. Kuntia? Is for all other respondent.
Other respondents are the state.
I am for 1 to 4.
And Mr. M.K. Kuntia and counsel appears for remaining respondents, i.e. respondents number 1 to 4.
Let me clarify that so far the single judge is concerned. Let it proceed.
No, on Monday, because I will disposing the written. There is nothing to be interfered with. You come prepared on that aspect of the matter. It is like just floating a kite to fly in the sky. That we will not allow in this jurisdiction. Sorry.
24.
May I please your lordship? My lord, as per honorable court's direction, inquiry was conducted. In the meantime, I have received the inquiry report. I have already inquired about the inquiry report, but my humble prayer before your lordship, since 2018, 3 families are unable to stay their residential village.
Because
there were some dispute. According to inquiry report, there was some dispute, and some villagers along with others ransacked the houses of the families, and they thrown out from the families. Thereafter, they
which is the concerned district?
Puri, my lord.
My lord, what has happened?
Everything on inquiry report, may I permitted to place only few lines of the inquiry report, my lord.
Let me submit one thing, your lordship. as per the direction of this Honorable Court, inquiry was conducted by the District Social Welfare Officer. We have submitted, last date, we have submitted the inquiry report. And if your Lordship will see the last order, the Honorable Court has directed that you file response to this inquiry report. Then only the matter can be heard or he has not filed any response.
May I
Let him file
permit
the
it only
response.
1 week will file response,
Yes,
my lord.
you can take.
Let the matter be listed on 31st of July 2023. In the meanwhile, the petition is permitted to file the response in response to the inquiry report submitted before this court. Mr. K. Pradhan and counsel has appeared for the petitioner, and Mr. D.K. Mohanty and counsel, additional government advocate has appeared for the opposite parties. Already filed. 31st July will take up the matter again.
My lord.
And we would request Mr. D.K. Mohanty, learned counsel, to take instruction from the opposite party's number.
DSW Puri.
No, opposite party number 4.
4.
Whether the petitioner can be rehabilitated at his place of residence. You just take whether if they go, there will be the possibility of any problem, or they can protect him if he should go there. To take an instruction.
Then your Lordship may direct the collector, because collector.
No, this is the duty, law and order situation assessed by the SP.
Yes.
Otherwise, we can also this.
No, it's okay. I will seek instruction from the SP. But in that event, your Lordship may fix it to first week of August.
8th of August.
10th of August.
Obliged, my lord.
Not 31st, 8th of August. Okay. Next. Just upload the matter.
Item 50.
Yes, madam. Lordship may kindly see the cost title of the appeal memo. The appellants before your Lordship are the Director Capital Hospital and the Director Drug Control Orissa. There are two agencies involved in this case. One is Director Capital Hospital, another agency is the Director Drug Control. Director Capital Hospital is the owner of this utility complex, and we are to let out the same to the appellant. That is the controversy. Second, the drug controller is the licensing authority who is empowered under the law to grant the drug license for the purpose of operation of a
drugstore.
Drug shop. Yes, madam. So there are, then I will take your Lordship. I will very short argument, though the appeal appears to be a very lengthy one, but I will take it straight to your Lordship to the direction of the Honorable Court at para 11.
Of the judgment?
Of the judgment at page 26, impugned judgment.
Yes.
Petitioner is entitled to engage in business and livelihood by running drugstore. The rule requires the licensing authority to insist
page
on
20C, internal page 5 of the judgment?
Yes, internal page 5. Yeah, obliged, madam.
All right. Para 11, you are
Para 11. To insist on a 5 years occupation period. In these circumstances, opposite part number 1 and 2 are directed to amend the said agreement dated so and so to be for a period of 5 years, commencing from 21st January 2022. Petitioner's occupation of the newly allotted shop under the agreement will expire on so and so 27. Notwithstanding, this is important. Petitioner will produce this order before the drug licensing authority, who is directed to issue license to the petitioner subject to compliance with other. My lord, my desperate submission is that there are two directions. One is we will amend the agreement from 1 year period to 5 years period, because there was a long-standing litigation between the Capital Hospital and the tenant, and ultimately the court has held that this they will be shifted from one place to another place, where they will be allotted with 2 shop rooms number 6 and 7. These are all undisputed. 7 and 8. I'm sorry, 7 and 8. And I will execute. The matter went up to the Honorable Apex Court. And ultimately, the agreement was executed with him for 1 year. Now, by the impugned direction, we are required to extend it for 5 years. That is one part of the story. So far as the extension of the lease period is concerned, although I have challenged in the appeal memo, but still I would like to, without any concession, I would like to submit. That is more or less not a dispute. We can, if your lordship will
grant
direct,
5 years.
it can be extended if your lordship direct. But the main contention is that whether any because he is trying this, because unless the 5 years.
No, I think just Mr. Maulik tried to understand that. He has been leased the shop area. He can run the drugstore there.
No, that is what I am submitting for the your lordship. Hear me for a moment. So far as the extension is concerned, now it is the discretion of the Honorable Single Judge has directed, your lordship will decide on. So far as the second.
No, that is why I am coming to that point.
Cannot be given, sir, because there is a government
Just
policy.
wait, try to understand what the court is making the observations.
Yes.
So whether the court can take up all the duties, responsibilities of the additional drug inspector who gives an information, the requirement to run his bona fide and everything, that has to be by them.
Yes,
We don't think this direction of the learned single judge is proper.
My lord, for issue a drug license, my lord, an agreement for 5 years is required as per rule 60.
No, that he's not. He's though has challenged it, but he's not opposite seriously. So if we just keep that direction of the learned single judge, other we will just say that it will be decided whether the license will be granted to the petitioner, the writ petitioner, or not, will be decided by the
government policy. That is
whatever they have to consider, they will consider.
I will take a single moment because that policy may kindly be seen. That is also annexed to the appeal memo. Clearly, it is held. The government has decided. This is the letter dated 27th February 2025. I'm sorry, 2015. I'm very sorry.
27th February 2015.
Your lordship may come to bottom. It is therefore been decided that B. No new opening of campus medical stores shall be allowed.
Yes.
So we cannot give the.
It is no medical shop. His medical shop was there. He has just shifted there.
Yes.
It is a special case. Sorry, Mr. That way, that you cannot take away his livelihood.
We are not. He can run any shop. He can use the premises. But now the drug licensing.
We will sell that. In his case, his shop shall not be treated as a new this medical shop in that premises. He should be treated that he was running an old shop. He has been shifted to that area. These are the undisputed fact.
Sir, then your lordship may come to A. No extension of lease on campus medical stores be done till further orders. So we cannot also extend. There is a complete ban all over the state.
This is a special case because you have shifted his shop to another part of the premises. You are not disputing.
That is not disputed.
So, and you are also tacitly agreeing that the 5 years lease also you will not challenge?
No, that is, we have challenged, but so far as that matter is concerned, that is not so important for us for the time being. The most important is that whether on the basis of the instruction, obstruction or the restriction imposed by the government, licensing authority can.
His shop should not be treated as a new medical shop in the campus because he was running that business.
He has applied for new. He has applied for
that. He will apply for this under the old shop.
No, he has applied for a new license. That is the point of consideration. Your lordship may kindly that it will go against the government policy.
Yes.
After as per their direction, have shifted my medicine shop from one place to another place. They have allotted, my lord. For the new place,
new license is required.
An agreement is required to be signed.
Not only required, new license is also required.
Yes,
under the drug
unless agreement lease agreement is signed, the drug license authority refused to you show the license agreement for 5 years as per rule 63 of the drugs rules. Then the drug controller will issue the license. That is the requirement.
The agreement for the old shop has it that period is complete.
Yes,
that is already complete. That is not true. That is complete since long. Thereafter he forcibly possessed it. Matter went up to the and ultimately the honorable court has said you immediately vacate and shift to the new premises, and they have shifted.
No, that is not under dispute.
That is not under dispute. Yes,
because you have allotted a new place for running a medical store. He was running a medical store.
He was.
since
Right,
long.
you have this ousted him from the place and asked him to go to the new place.
It's not question of ousting,
In the
Milord, because we require that place for the development
why
of the hospital.
ousted
So
means
that is
you
a
have ousted
utility
him from
complex.
his own place.
We have organized a utility complex where all these hope
We
owners
all
were.
understand. We are not questioning that part. We said after all, you rehabilitated in a new 2 shops.
Yes.
Right? It is you. In exchange of the shops you are occupying in the part you have taken over for building, constructing this utility space.
Sir.
So that is there. You
So
are now
my respectful submission, your lordship may kindly imagine. Now when he shifted to the new shop by order of the court or by our endeavor, he has been shifted to the new premises. He has again applied for new application for which is covered by this notification. The drug controller cannot go beyond the policy decision of the government. So how can we give the license when the government has decided that no license will be there is nowhere in the state?
all right. We'll giving the directions that these aspects will be considered and they take a decision as per the policy and the rules.
Policy, your lordship may indicate this policy.
Because the new
new
opening of the campus medical campus or the new license is relating to the person who have just entered into the fresh business.
No, it is no extension will be granted. That is the.
But you have given the extension.
Even if there is a existing shop, we will not extend the license. That is the there. We will not extend the tenancy because the government as a policy stopped everywhere in the state. There is not a your lordship will find not a single 24/7 medicine shop inside the premises. It will be a precedent. Your lordship may kindly imagine.
No extension of lease.
No extension of lease.
But you have given the 2 shops in his favor.
New lease.
Whatever you have given it.
Yes.
In the capital complex, capital hospital complex itself.
Yes.
So this clause is not applicable in the circumstances.
No. But this then B clause is applicable if it is newly allotted and he has made an application in respect of that.
That will be considered by the drug controller taking into the situation. He was also holding an old drug license for running the shop. Now, if they want to treat that as he's a new entrant in the business, they will treat it according to the rule.
May I pray one thing to
Yes.
your lordship may indicate that taking consideration this particular government guideline because we have repeatedly.
All right, we say that we have appreciated this restriction imposed by this letter of 2015.
Yes, ma'am. And taking consideration that the drug controller will take.
All right, he expects how to consider it also. We'll also observe that because we know how the officers will consider.
Earlier policy decision.
Mr. Maulik, just when the
My
court
lord,
is hitting up the iron, don't just hammer on it.
no, my lord, your lordship is, I understand your lordship is, but so far as the policy decision is concerned, if only in one place we will allow, then the entire state everywhere.
If these special circumstances are available in all other
That's not a
cases,
special circumstance. That is
why
the
have you
responsibility.
given him this allotment in the 2 new shops?
That is because of the order of the honorable court.
That is why there is a purpose in that
But
order.
honorable court has never directed.
You
for
will
the
allow
first
him to
time
the sell vegetable in these shops.
He can use it for any other purpose.
I
We
will
have no-
record that.
But so
If
far
you
as
say
the
any
drug,
other purpose, why not drug?
my lord, that is what I am saying because your lordship may kindly see, lease granting authority is different. That is the capital hospital.
All right.
And the licensing authority is different. Lease granting authority is abide by the directions of the honorable. Your lordship may kindly hear me.
We
for a
understand. Yes, then.
They are guided by the Honorable High Court's order, 1 year, 5 year, they have nothing to say. But so far as the licensing authority is concerned, licensing authority is guided by the government policy decision.
All right, we'll say the policy, and when considering on the basis of the policy, we'll just identify certain facts, that to consider those facts. So no, there cannot be any arbitrary act on the part of the
No,
government.
it is not arbitrary.
That
but
is why you will say that he was holding an earlier also a drag license.
My lord,
And the government wanted that space. He was shifted to the new
may I submit
place.
one thing, your lordship?
That will say.
There are
because it
hundreds
was-
of, my
on
lord,
his part, it was a completely an involuntary act.
my lords must be knowing there are hundreds of 24/7 medicine shop inside campus and everywhere we have stopped it after this promulgation of this.
But it's a
government
special
policy.
case. Why don't you
It
understand?
is not a special case at all, my lord, because they are only interested for the shop room and they fought the case for that shop room. So far as license is concerned, they have applied for new license, which is governed by this. That your lordship may kindly record
There
my
the authority
statement.
does know your policy and how to decide on the application. Court doesn't require to give them any directions, how to consider those applications. That is where
In view of the policy.
Obviously, we'll share as per
Then your
the
lordship- Your
rules.
lordship may dispose it out. Your
We'll share
lordship may
as per the rules.
Because
Because we will not also bringing in the policy, we'll say that as per the rules. Rules means the drug rules.
rules is there and government policy is also there.
All right, we'll say that as per the rules.
Yes.
All right. If they say the
And
policy is
I
the
also
part of
pray
the
your
rule.
lordship to indicate this policy, because we are only harping on this policy.
You harp on the policy, if they consider the policy is the part of the rule, they will consider it. Why you should make a such policy very restrictive in nature, made it the part of the rule?
That is the only thing which I wanted to place. They have not challenged this policy.
All
This
right,
policy is not
should
challenged.
I go to the drug rules, 1950?
That is there. But this
That is what is there.
policy is
What
also
is there? This person seeking the license will show a premise which will be given in
5
the
years.
schedule.
5 years.
Yes, 5 years is the minimum requirement of
This
the
has to
lease.
be read along with that.
And then thereafter, there are other conditionalities elaborately arranged in these rules. They will consider all these rules whether it is covered by not. If they consider this, they will follow the government policy, they would follow it. Right? We are no one to say all these things.
Because
We will only observe as per the rules.
had there been any such observation by the learned single judge, we would not have filed appeal, because your lordship. What your
Okay.
lordship is saying, because the honorable single judge has issued a direction that that is the only thing. Because that means
That is why it is my view. I do not know what Justice Roth will say about it. That whether you should intervene in that
our
direction
only,
also.
my lord, our only apprehension is that if one allows,
Because my view is that we should not denude the statutory authorities of their power of exercising whether license will be given or not. Let them exercise their powers. We have not quarreled with their power.
that from the very beginning, your lordship has that this is the prerogative of the licensing authority to consider the application, keeping in view the rules and the government guidelines.
That part is your observation, not our
No,
observation.
no, this is not my observation. This is my prayer. This is my prayer. That
Okay, I've said as per rules they will decide. If they think, because this rules also, this policy also regarding the premises. If they want to consider this restriction, they will consider it. Why should we mention it? I will mention this part
Unless-
in as your submission.
I understand your, but
No, I will definitely record your submission. You will say that this is the policy that is being strictly to be followed at the time of, this is the government policy. It is
that's
also,
okay. That's okay. If
that will
that's
say.
okay. That's
Ah,
okay.
That is what I am
sufficient.
proposing.
That one line
But
from
in
your
our
lordship
direction,
now is
the policy word will not be there, only the rules will be there.
no, under this policy, we have discontinued the license of hundreds.
All right,
Then everybody
I think that you have submitted that this is being followed by the authorities. If that is followed. We are not restricting them that don't follow this policy. Got
Yes.
my point? The court cannot take part beyond the rules because they are supposed to act within the precincts of the rules.
But
Now
my
by
lord, this policy is
Mr.
also.
Mohanty,
Yes,
that
my
if
lord,
you
I'm
go
sorry.
to the constitutionality of this order, that will make you push you into more trouble.
No, it's okay. What your lordship is thinking that.
Because you're coming in conflict with the central rules. This is not under the state subject at all. Got my point? So this is your policy regarding the management of the spaces inside the hospital.
That is second.
Right. That is why we will say that you have stated that this is being followed by the state government for welfare of the people in general who are taking the services from this hospital premises. We will observe that. We will not say they don't apply this policy. We will indicate there is an existence of such policy, but we will not direct to follow this policy. We said that decide the license as per the rules. Got my point? Yes.
And your lordship, they are undertaking before the Honorable Supreme Court, that is writ petition annexure 5, page 24 and 25. They undertook before the Supreme Court to give, that is writ petition page 25.
That is all regarding allotment of
Yes,
space.
only.
That is, we are not disputing. That is regarding all allotment of space in the.
Which writ petition? There are two writ petitions.
14917. Double petition number
My lord, all these
14917
litigations,
of 22.
all these litigations are relating to allotment in the utility complex. That part is closed.
Writ petition number, double petition number 14917 of 22. Lordship got it, man. Page 24 of the annexure 5 of that petition.
Those things are not to be now taken
let me-
because those are already closed.
He is also not seriously opposing that regarding the allotment of his shop and 5 years lease, he says it will be granted, but he has requested us not to record his concession in the order.
Yes.
That is what, because he's not under instruction, try to understand his limitation also. He's not opposing you strictly, that can be done. This is not an issue. But regarding the license, the Learned Single Judge's order is a little bit taking over the power of the licensing authority that usually the court shall not permit. That part we will just dilute and observe differently. We will allow them to consider according to the rules and also record Mr. Mohanty's submission. The state government has adopted a policy for observance at the time of issuance of the direct license. We will not say follow this or not follow this. We said only according to the rules. Got it? Mr. D.K. Mohanty and counsel appearing to the appellant.
You have no problem, which has been extended from 1 year to 5 years.
This period that is
That you can run any other shop, but as per your policy,
exactly. He can run any other. There are so many shops in this utility complex, hotel, that stationery shop.
Okay.
High Pures 1 year, and your lordship will appreciate the agreement was for 1 year with a clause that it will be renewed time to time.
Yes, Malik. And counsel appearing for the respondent within bracket the read petitioner. By means of this intercourt appeals, state appellants has challenged the order dated 8th August 2022. Delivered in WPC number 14917 of 2022. By the said judgment, the Learned Single Judge has observed and directed as follows. Code para 11. Stop. Mr. Mohanty, senior counsel, sorry, the additional government advocate, was seriously contended that since the petitioner was persuaded to shift the shop for construction of the utility space within the Capital Hospital complex, as per the direction of the Apex Court, he has been granted 2 shops.
The lordship may mention shop room number 6 or 7
7
and 8.
Shop room has been accommodated with 2 shops being shops number 7 and 8. Stop. The dispute between the appellants and the respondents was taken to, dispute relating to the allotment of the shop was taken to the Apex Court by the respondent herein by filing a special leave to appeal being SLPC number 2069-679-2021, Annexure 5 to the writ petition. While disposing the said special leave, the Apex Court has directed the appellants to complete the process of allotment within a week from the date of order, i.e. 17/1/2022, and also to sign the agreement accordingly. Mr. Mohanty, additional government advocate, has clearly submitted that process is over. And the shops, the above shops have been allotted in the name of the respondent. But he has fairly admitted that the lease that has been, the agreement that has been entered between the parties was for a tenure of 1 year.
For 1 year.
For 1 year. Stop. At this juncture, Mr. Maulik, learned counsel appearing for the respondent
My
submitted.
lord, may I interrupt? For a period of 1 year, in view of the resolution passed by Rogi Kalyan Samiti, because there was
In view of the resolution passed by the
Rogi Kalyan Samiti Capital
passed
Hospital,
by
Bhubaneswar.
Rogi Kalyan Samiti of the Capital Hospital.
Bhubaneswar.
Stop. It may be mentioned that Rogi Kalyan Samiti has no status, but the governments for maintaining the good relation between the patient and the hospital services, maintaining the good hospital services, they have formed such committee as a part of the program, and their role is restricted to that of an advisory role. Stop. Mr. Maulik, learned counsel appearing for the respondent has stated that the respondent used to run a drugstore in his astral shops, and he would like to continue this side business of drugs under the valid license. But for getting a license, minimum 5 years lease period is required to be shown to the licensing authority. Stop. It appears that in that the requirement in view, learned single judge has directed the appellants to amend the said agreement dated 21/1/2022 by enhancing the tenure from 1 year to 5 years from 21st of January 2022. Stop. According to us, the said direction is not unreasonable, inasmuch as the rehabilitation of the petitioner shall also include and make him eligible for getting the license, drug license, in accordance with the drug rules in the new premises. As such, we are not inclined to interfere in the said direction.
Your lordship has recorded that.
Which one? Stop, new premises, stop. Having appreciated the submission of the learned counsel for the parties, we are of the view, the fact that the petitioner was running a drugstore in the same complex, but not exactly in the same premises, be also be considered by the drug licensing authority at the time of considering whether the petitioner is fit to be granted with a drug license or not. Stop. While considering the grant of drug license, all requirement of the drug rule shall be conformed to. Stop. We direct.
And this notification should be adhered to.
I have stated it. The facts that you both
But
of you.
this is the observation part, which is.
No, that will not. I have said I will not say that because it is not a part of the drug rules. You are imposing certain things on the drugging authority guided by a central rules. That's not, you cannot do that. You can, so far the premises is
Because
concerned.
This fact was also challenged before the Honorable Apex Court, that was also dismissed.
Dismissed. Well, just show from the order.
No, there is not there in the impugned order, but I can, that is because this decision is binding. My lord, this policy decision is binding.
Yes.
So Lordship may observe that also. That only that will suffice.
Which one?
That keeping in view this policy decision also.
I have stated that.
In the observation part, in the direction part.
All right, no, that I will not integrate that with the consideration. Sorry, Mr. I will not do that.
Yes.
Because you are trying to supersede the statutory rules, which is the central government's jurisdiction, to add something without something. You are just restricting. Then you don't give the premise to him. The moment he gets the premise, he can run any business.
Yes, he can run any business.
Yes. Yes.
We are only concerned with issuing license,
All right, they will
license.
consider premise is a part. You read, I think this is a rule 66 A, B, and C. Right. The premise will be inspected by them, whether it is fit for a drugstore or not. And we have mentioned that you have stated it is the state policy. And drug controller has been requested to follow this policy. These three we have quoted already.
If that
by,
My lord, agreement is already there, it will be amended. Agreement is already there, it will be amended
but they enter, this is an entering into the fresh agreement also.
Now that
To
agreement
amend
is-
the agreement or to enter into a fresh agreement by extending the tenure of lease / period of occupation for 5 years from 21st January.
that is already there. The agreement is there. It will
5
be
years from the
simply
date of
amended.
signing of the agreement.
Huh?
5 years must be from the date of signing of the agreement.
Yes.
Or from the date of signing of the agreement.
No, the London single judge says 21st January.
21st January is the signing of the agreement.
From the date of the signing of the agreement dated 21st of January 2022.
Yes, that is already
All
signed.
right.
It is only extended.
Right.
We will
That can be also by your one letter. We just
That is what I was submitting. I will
Still,
we will
right.
only give a letter that your lease period is extended.
All right. But that only be signed by you. That's all.
Yes, the director will sign.
So also the extension may be granted by the unilateral communication that
By the director, Capital Hospital.
Huh?
By the director, Capital Hospital.
by the director of the Capital Hospital, the appellant number 2, by communication to the petitioner. Stop. And that such communication should be part of the agreement for purpose of paying for the drag
Completion of the lease
license.
period, for the purpose
For
of
purpose of paying for the drag license or any other business. Stop. We direct while considering the prayer of the petitioner for granting the drag license authority shall be guided by the relevant rules /
That may be
policies.
application of their application for lease.
They have applied, otherwise, well, these complications. Stop. In accordance with the rules. Stop. If the application is filed complete in all respects, such application shall be considered within a period of 30 days from the day when the application will be made with all relevant documents. And you are within 7 days?
That letter can be within 7 days.
And the respondent number 2 shall either amend the agreement by enhancing the period of tenure to 5 years or issue a communication by extending that period to 5 years within 7 days from today. In terms of the above, this appeal stands
My lord.
partly allowed.
My lord, may I take only 1 minute more? In the appeal memo. at
You
page-
just tell your government when the drug license is issued under the rules of the central government, they have no business.
That is what I am submitting. These
Yes.
guidelines were under challenge before the Honorable Apex Court in a reported case 1995 1 SCC 652. That I have mentioned in the appeal memo at page 12.
What is there?
That stood confirm.
All right. You just
That we can take note of while accepting or rejecting his application.
all right.
Oh, that was when all those 24.
Yes, 24, all 24/7. That was challenged before the Honorable Apex Court.
What is the citation? Read
Your Lordship may kindly have a glance at page 12 of the appeal memo.
There the facts were different, my lord.
No, same.
No.
That
Facts
is
are
only
different.
allowing within the premises of hospital 24/7 drug.
We'll check if that is that policy. You have the decision with you.
Beg your pardon.
What is the citation?
That is in the second para, page 12.
Page 12.
95-1 ACC.
95-1 SCC 652.
somewhere when Mr. Mohanty's submission is recorded.
That thing has been.
Honorable single judge has also taken note of
You
it.
just made a
Saying it is
paragraph.
not
Now I'm
applicable.
dictating that. It has been also stated by Mr. Mohanty, this ABC, that the said guidelines was, how can it be challenged? It was a 2017 and this
That is,
decision is a
that guideline
95.
is not challenged, my lord.
No, guideline means this
No, no.
decision, this guideline was the decision for not allowing some people.
All right, Mr. Mohanty and council has submitted that decision of the capital complex, the capital hospital authorities not to allow any further fresh drugstores.
Those that case, my lord, the shop owners,
Let us check
inside
that.
shop owners had filed the case not to allow any other shop owners outside the capital hospital.
That is what I am reflecting.
That is what my
That-
lord is.
that-
Then that is
That
the
is what my lord is.
Not to allow to open 24/7 drug distribution center
Confirm.
within the capital complex, capital hospital complex.
My lord, that is on all hospital complex, I think.
No, all hospital complex was challenged before the apex court. And the apex court has stated that the such restriction has observed in state of Orissa and another versus Radhesham Meher. It is page 12 at the bottom, citation. And others, colon 1995-1 SCC 652, that such restriction doesn't offend the right to carry on business under Article 19(1)(g) of the Constitution. All right.
Oh, please.
Item 74.
May I be kindly permitted, Your Honor?
Yes.
My lords, this appeal has arisen out of the judgment and order dated 1st May 2023,
Yes.
passed by the Honorable Single Judge in WPC number 9850 of 2023. In order to appreciate the submissions made in this appeal, on the last occasion, Your Lordship have admitted this petition, appeal for hearing, and the matter involved in this.
I'm appearing for Bhubaneswar Development Authority
Huh?
respondent. I'm appearing for Bhubaneswar Development Authority respondent. Well, it's kind of a glance to order that 17/7/2023. Their minors directed to get that brochure of the scheme.
Yes.
But in fact, minors brochure of the scheme is available there in the appeal in Annexure 1, minors.
Yes. This is the only brochure.
All the brochure.
All right.
Annexure 1. Minors wanted to see whether there is a provision of 2% discretionary quota for BDA employees or not. That is what minors observed. Minors,
This is the 2% quota.
Quota minors observed in paragraph 5. There minors kind of a glance to page 25 of the appeal memo, minors.
My lord, serial number 9, reservation.
Page 25 minors got it, man.
Your page 25?
25 of the appeal memo, minors.
Huh.
Learned senior submitted minors filed it, appeal memo, minors.
You just referred to
That
the
is
para.
Annexure 1 at page 25.
Para?
Para minors 9. Reservation.
Reservation.
Reservation. 5. A5.
This he is claiming BDA staff under regular
BDA
establishment,
staff,
2%.
But minors, the thing is that minors, the matter to be considered on merit. Fact remains he got one plot for residential under discretionary quota. Then he sold it to on third party transfer, on prepossession transfer, he sold it to minors one Farat Nijami. Then he purchased another plot under commercial category. But then filed an affidavit. They're suppressing various material facts. And anyway, he got that plot. Now he is in possession of that commercial category.
Yes.
Then third plot under this scheme he applied for. There this 2% discretionary quota. And also,
What is the purpose of asking you to produce this brochure is because they show me, does you have put any restriction that someone purchased one plot under this special category, they will not be allowed to purchase second
That, my
time.
lords, I will bring, my lords, the decision of the Honorable High Court where this 2% category reservation was quashed, including discretionary reservation.
Cost is one thing.
In one case, that is the 91,
No, not that.
1990,
That
was-
there is the
that was.
Just a
principle.
minute, just let me
Principle
have
laid
the
down there.
clarification. Ah.
Principle laid down there that 2% reservation in respect of that quota is not maintainable at all. Those who have taken possession, that's all right. Those who have not taken possession cannot take over possession. In this case, he has not taken over possession. That's one aspect.
Which is the decision of this court?
Because that decision, my
9/4,
lord,
2002. My lord, that is 9/4,
Just
2000.
let him show
And that
this.
decision was rendered in the 1991 Kalinganagar plot scheme.
Wait, let us see the decision, whether under the same.
Well, my lord, not Lawrence, brother has enclosed it in Annex page 51 to the appeal memo. That decision was not reported then, though it was a judgment by division bench and laid down the law, but it was not reported, my lords, then.
I think subsequently it has been reported after some years.
Page?
Page 50, it starts from page 51.
From memo of appeal.
My lords, of memo of appeal.
My lord.
It will take some time.
Just a minute.
Well, it's got it, my lord. Then page 66.
My lord, since this matter will take detailed examination of all the materials that were placed before the honorable single judge in the writ application, and on what material facts the writ application was founded, then what was the stand taken by the Bhubaneswar Development Authority in their written counter affidavit, then what was the judgment rendered by the honorable single judge, and in what way that was.
Are you going to auction out this?
That is fixed for auction on 26. My lord,
Because I think this matter will take some more time.
Yes, my lord.
So don't take any action till the next date. We are fixing the matter on 8th of August.
go for auction, but I will not take a final decision.
No, don't go for auction even.
No matter. Whatever my lord, I can, judicial order, my lord.
Because I think there is something to be examined by.
All right, my lord, well, because it is
As agreed by the
decision.
council for the parties, let the matter be listed on 8th of August 2022.
That
Till
is
then-
Annex 11, my lord.
The auction notice?
Auction notice dated 24th May 2023.
Annex 11.
That is Annex 11 in IA number 3241.
I number?
3241. Filed on 16.
All right. I got it. Till then, the auction in terms of the notice dated 24/5/2023. It is already, time is over.
No,
Auction
date is when it's on 20.
Receipt of application is
26.
over. That was
Receipt of
23rd.
application.
26/7 is the date.
26/7.
Date of
Auction, that the auction in terms of the notice dated 24/5/2023, annexure 11 to the memorandum of appeal, which is scheduled on 26/7/2023, shall not take place. Stop. Shall not take place until further order.
Small prayer matters. Fact means it is an e-auction process. Already persons applied for giving money, depositing money and all these things. Now, auction, if auction will not take place on the particular, because e-auction transactions.
We will not allow to create the third party rights when deciding a
No
matter.
question of creating third party right.
Yes, obviously, will the successful in the auction, his right will be created. So wait for that till then. All
I'm
right.
concerned with that, but fact means these persons, those who have applied already, but now they have deposited huge money, my lord.
But just wait until further order and make.
Exactly, my lord.
That is
what I
until
pray, my
further.
lord, fixing a sort of
We are
date.
not squashing this auction notice. We are you just notified it is deferred subject to the order by
My
the
humble
court.
prayer to fix a date, my lord. My prayer to fix a sort of date so that it can be taken up, because number of people might have applied.
No, it's all right. The applications will remain. We are not touching the
Exactly,
process.
exactly,
It
my
will
lord. I
not
only
take
pray,
place on
maybe
26th
taken up a
July.
sort of date.
Okay. Mr. Sajjan sir, just giving the names. Mr. P.K. Tripathi and counsel appears for the appellant, and Mr. Dayananda Mahapatra and counsel appears for the Bhubaneswar Development Authority. All right. Call the other matters first. Go
First
to
fixing it, Miles,
this
fixing-
corpus matter first.
May I prima- fixing it to fixing Miles, fixing a date, Miles. So for this item,
8th of August.
8th of
My lord, on 8th of August, I will be at the Supreme Court. On 6, 7 and 8, for 3 days, I am going to Delhi. So another date after 8.
What can be the date? 17th of August.
Yes.
8th.
18th of August.
17th of August.
Miles, be pleased to record my objection, objection raised. Miles.
The Mr. Mahapatra and Council has seriously opposed the intervention in the auction process. Next.
62.
We are taking the.
Since he
Oh, then?
Yes, so he is an issue, so therefore I make a mention.
And it's all right. We are fixing in 25th of August for disposal.
Top of list, if your lordship.
No, top, we are listening. You mentioned that we'll update the matter.
As your lordship.
7, let the matter be listed on 25th, 8, 2023. Mr. A.N. Patnaik and council has appeared for the petitioner, and Mr. M.K. Khuntial and council has appeared for the Orissa State Housing Board. You are appearing for Orissa State.
I am for the state, Mr.
Dayananda
Mahapatra was
the Odisha correspondent number 1.
All right. So Mr. Khuntial has appeared for the state opposite parties, state respondents. Yes.
Item number 61.
25th August. 25th August.
Item 28.
68.
61. PIL matter that it was fixed today, maybe taken, if it can be taken up today, tomorrow.
Item 26, my lord, kindly taken up.
Have you supplied a copy to the Dr. Das?
Item 61, my lords.
You are there.
I'm there. I'm there. I have received an instruction which I'll place before the lordship tomorrow.
No, has that been supplied
Supply
to
a
the
copy
council?
to Dr. Das so that he can also examine.
That is a letter from the Home Department to all concerned collectors.
We
So I'll
know
give a
that,
copy.
but give her a copy.
But you have not complied our order. We asked you to file a comprehensive
Today I have filed my
affidavit.
affidavit. We will do that, my lord. The lordship will grant some time, my lord, because.
Also, this copy, this is a harmless communication. Supply a copy to Dr. Das.
Yes, please. I'll do
All right, in the course of the day.
Yeah.
How much time do you require to file the affidavit?
My lord, once we receive this information from the
That is a vague
collectors.
statement. No, receive the affidavit is under your control, your administration.
Yes, that will do. We have called this 18/7, this letter has got. Your lordship will grant us 10 days time to immediately call for responses, and then we.
We were fixing the matter again on 8th of August, more than 10 days.
2 weeks time, your lordship will grant us.
You are getting 2 weeks.
18 days time you are getting.
Yes, yes, agreed.
6 months have passed. From the date of the order, 6 months
Wants or doesn't?
already passed, and
No, no,
they are
it's
not
all-
complying, and
No, that is why because
first
now they.
affidavits are filed.
No, that is why a copy will be provided to
Yes,
you.
yes.
Is a communication they have
Today
made
also
to
I
the
have served the copy of the.
all the collectors and other things seeking the information in terms of our order. And they say if 15 days time is granted, they will be able to file the affidavit. So you're fixing the matter on 8th of August. And no
Personally
further,
discuss this matter with the Home Department, my lord, and conveyed your lordship's concern about this matter. Your Honor.
it is not the concern of us, it's a concern of the statute itself, right? Heart doctors is thus learned counsel appearing for the petitioner. Dr. Das has expressed a serious concern about the delaying tactics of the respondents in filing the comprehensive affidavit as directed by this court. However,
Today
Mrs.
filing
Patnaik,
also
learned
the
counsel has
affidavit.
produced a communication dated 18/7/2023 by which the Home Department has asked the various authorities, these all district magistrate, labor commissioners, all heads of the department, principal secretaries, all superintendents of police and the deputy commissioners of police to furnish the information in terms of the order of this court stuff. At the request of Ms. Patnaik and additional government advocate, we post this matter on 8th of August 2023. We direct the state authorities file the comprehensive the affidavit before on 7th of August 2023, after supplying an advance copy to Dr. S. Das and counsel is appearing for the
As
petition.
per the direction, I have filed the affidavit today.
So the petitioner has.
I have served the copy on the
filed
central government as well
filed
as
the affidavit in terms of our orders. You have filed it in the registry or here?
just now I am filing it with,
Already
because
filed
it
in
may
the
not
proceeding,
be
which is taken on record.
and served the copy on in the
Already.
office of Advocate General and
Already. Keep all of this.
the central government.
We have taken on record.
Yes, item 28. Item 28. Item 28 plus. It is regarding the disposal of drugs plus day-to-day basis plus that case is being monitored. And today I am also filing the affidavit pursuant to the last direction. Also, it is already filed. The drugs which are being seized during pre-trial stage as well as post-trial stage, the drugs are being disposed of pursuant to the direction of the Honorable Court as well as the direction of the Honorable Apex Court in the case of Mohanlal.
Yes, yes.
You'll also see paragraph page 2, there I have given a table.
Why after the Mohanlal, this public interest litigation has been taken? It is not being complied with by the government, particularly the seizing officials.
Yeah.
Because the additional Inspector General of Police has been designated as the chief disposal authority at the state level, and there is a district level authorities have been created under the Mohanlal.
Yes. Yes. Plus, because
what is the problem now?
Because of some anomalies, plus we have filed an application before the Honorable Court, which has been taken on the judicial side, and also judgment has been delivered by the Honorable Court, and thereafter the drugs are being disposed of, and we are filing the status report on every date. And by now,
I will request you to go to the Malkhana of the Bhubaneswar District and Sessions Judges Court. Then you'll see how the drugs are disposed of. What
by now, plus 275 tons.
What yes? Tell me.
No.
Do you know what is there? The ganja full in the filled up in the sex of polygamy in this thing, and you says they are being destroyed.
That's the position. That was the position everywhere, and that's why our officials have taken so much efforts. Also, the judicial officers also helped a lot. That's the reason why we have, in the meantime, we have destroyed 275 tons, 7 quintals, 13 kgs of ganja. So also will get it from the table. That is at page 2.
We'll take up the matter not today because in a hurry we cannot pass order. We'll take up this some other day. When can we? Okay, no. Okay. You file in the registry. We're giving a date. Return it. Of August? No, it will be taken early. July? 27th July.
Item
Unless this
26
matter again
also.
on 27th July 2023. Meanwhile,
Item
meanwhile, the state of Orissa shall file their affidavit is asked for. Mr. J. Kotokil, an additional government advocate, has appeared for the state respondent.
Item 26, your lordships. A counter is required from the Raulkela Development Authority. The state has brought the counter its record, my lord.
Counter I am filing just now. I am filing the counter of the first item, where he has appeared. I also filed the counter of the second item. And your lordship director, though he is not a party to the second item.
You please, you kindly just use the microphone.
Sorry, my lord, he is appearing for the second item. Your lordship director will solve the counter of the first item to him also. So in the second item, I am solving him the counter. On the first time, also the counter copy I am solving. Both the counter I am solving him.
All right.
Ready with me.
The interim order to be extended, my lord. I am in virtual mode. I am for the petitioner, my lord.
Yes, we are make the interim order also virtual.
Item.
You are appearing for whom?
I'm in the first item, my lord. I
First
for the
item.
petitioner, yes. Mr. Jena is appearing in the subsequent connected item.
Microphone.
I am appearing for the petitioner in the first item, and Mr. Jena is appearing for the petitioner in the connected item.
You are Mr. Das, Siddharth
Yes, my
Prashad
lord.
Das.
Yes, my lord.
So in the first item, item 26. Mr. Siddharth Prashad Das appears for the petitioner. So Mr. D.K. Mahapatra, you are Mr. D.K. Mahapatra?
I have opposite part number 1 in item number 1, opposite part number 4 in item number 2.
Mr. D.K. Mahapatra and counsel with the opposite party number 1 has submitted that the opposite party number 1 has is going to file the affidavit in the course of the day.
I have already filed. I am serving the copy.
Where have you filed?
Filed long document.
Although this opposite party
File on
number
record,
1 has
that's on
filed the counter affidavit. But earlier, no copy was served on Mr. Das and counsel with the petitioners. Mr. Mahapatra and counsel has served a copy today in the proceeding to Mr. Das and counsel. Stop. In the second item, Mr. Jena, no? What is?
He is in virtual mode, my lord.
Where is he? Only person is Ms. Patnaik on virtual mode. Just to bring Mr. Jena, is it
Yes,
waiting?
my lord. I'm in.
Yes.
Am I audible?
You are audible, but you are not visible.
My lord, I'm unmuting the video now, my lord. It's like you cannot start your video because the host has dropped it. So I'm not able to.
Court has not dropped it, Kate. Court has made you waiting in the room that whenever your matter will come, they'll open it. But now, court also cannot open your studio.
My lord, I have unmuted, but it's not coming. My face probably is not coming. Now it's all right.
Yes, now it is very much audible.
My lord. Here, my lord, I only pray that the interim order dated 15/7/2021 may be allowed.
Mr. Same, Mr. Subhasis P. General and counsel has appeared.
Please switch on your video.
Submitted.
I have already, madam, I have already switched.
But you are for the opposite party number 4 in the second item?
I'm sorry, my lord.
Second item.
WPC number 27662 of 2001, I am for opposite part number 4. In WPC number 1948-21, I am OP number 1.
All right. In 19482, second item, Mr. Sajjan says, PK General and Counsel appears for the petitioner. So Mr. DP Mahapatra and counsel appearing for the opposite party number 4 has submitted that. The opposite party number 4 has submitted the counter affidavit. Stop. Interim order is passed earlier, shall continue. Let the matter be listed on. Let the matter be listed on 25th August 2023. Both the matters same.
Highly grateful, your lordship.
I beg your pardon, my lord. I beg, sorry, date, my lord.
25th August.
25th August.
Item 63, my lords, interim order to continue.
Item 63, interim order is list on Sajjan's date, give the date. Interim order is passed earlier, shall continue.
Item 25, my lords, a form date may be given. Any form date.
All dates are firm.
It will be provided after some time you come and collect. Send someone in the given date. Yes, Mr. Pari.
Item 49, there is an interim order which is.
Item 49, give a date.
Item
49.
Interim order is passed earlier, shall continue. Mr. Pari, counsel assist Pari, then additional standing counsel.
I am for the appellant here, private.
Appellant?
Private.
The land counsel appears for the appellant.
May I seek indulgence to congratulate the option?
Thank you. It's okay.
Our congratulations, my lords.
Thank you.